But at the end of the day, I think there's good and bad aspects, even on the conservative side of this judgment. On the substantive due process point, undoubtedly, some of the modern substantive due process is just outrageous. The Roe v Wade stuff is a good example where they have concocted this essentially, where it was never a fundamental right in the US. It was never considered a fundamental constitutional right until the court declared it to be so.
Welcome to the Macquarie University Liberal Club Sunday Sessions podcast, live from the Facebook main page. My name is Andrew Cameron, and I'm joined as always with Isabella Anderson.
Hi.
Good to see you again.
You too.
Roe v Wade has been overturned in America 50 years after the initial ruling. To discuss the legal implications of this, we are joined by our good friend Cameron Shamsabad, writer and solicitor and founder of the Australian Constitutional Law Journal. Cameron, welcome back.
Thank you, Andrew, and thank you, Isabella. Very nice to be back again. I think we were mentioning before we started, fourth time now, and I'm very glad to be back with Macquarie University Liberals. I can't say no to you guys, apparently, when it comes down to it. I absolutely love talking law with you, and I'm very happy that we're going to be talking about this case today because this has attracted quite a lot of attention, and I think very few people are obviously understanding what the legal implications and what the legal background is relating to this Dobbs and Jackson's Women's Health Organization decision actually are.
It's certainly hard to get something so thorough from the mainstream media, and we were just talking just before we went on air. It's really something. So we're so happy to have you on, Cameron. As always, you can ask a question in the comment section, and we'll try and get to as many of them as we can within the hour. So firstly, Roe v. Wade was to do with interpreting the 14th Amendment of the Constitution in regard to making abortion legal. Can you explain how Roe v. Wade read this amendment in relation to it?
Certainly. Well, in order to canvass the idea of, the ideas that were discussed in Roe v. Wade, we must first put this decision in the context of a broader constitutional framework. So it's not just the 14th Amendment due process clause that we would be talking about. We're also talking about the First, Third, Fourth, and Ninth Amendment of the US Constitution. And this is what forms the basis of a constitutional penumbra that we find set out in Griswold v. Connecticut, which is a 1965 case. Essentially, what we have in this Griswold v. Connecticut case in the 1960s is we have the foundations for Roe v. Wade being set. If we go back to the 19th century, the 14th Amendment was essentially created for the purpose during the Reconstruction period of allowing the federal government to ensure that the rights of citizens and the equality of citizens was maintained and protected. Due process, equal protection of laws, citizenship rights, all of those things were protected in the state governments through the federal constitution. So it essentially, through incorporation, applied the first 8 amendments of the US Constitution onto the states. Prior to the passage of the 14th Amendment, that hadn't been the case. The state governments had their own bills of rights and they had their own protections. The federal constitution, the Second Amendment, none of that applied to the state governments in their legislative powers. The 14th Amendment comes through. Now we have a federal constitutional rights system imposed upon state governments. So state legislatures actually have to preserve and protect particular rights, or at least not infringe them. And within the framework of this, we get essentially Griswold v. Connecticut in the 1960s, which is a substantive due process case, which says that the substance of the law which was in question was essentially arbitrary and unreasonable. The law in that case that was in effect was a state law which essentially restricted or prohibited the use of contraceptive devices and medications by married couples. And what the Supreme Court essentially said by a majority of 7-2 in Griswold v. Connecticut was that there was a domain of privacy around the marital relationship that the state governments could not invade, such that they couldn't regulate contraceptive devices and medications and prevent couples from using them. And essentially they had a wider conversation about this within the judgment, but the essence of it was by 7-2, the majority accepted that. The majority of the judges did say that it was based upon the First, Third, Fourth, Fifth, and Ninth, as well as 14th Amendment. So this penumbra, which essentially is we imply from this collection of rights a right to privacy. And the way that you would get to that is you would use the First Amendment in relation to association, the Third Amendment in relation to quartering of soldiers, which is unusual, but the way the court looked at this was it establishes the sanctity of the home. You have the Fourth Amendment, which essentially establishes the right of the people to be secure in their homes, as well as all their papers, effects, etc. The Fifth Amendment against self-incrimination, which is enabling citizens to create a zone of privacy around themselves. And the Ninth Amendment, which is very fundamentally protecting unenumerated rights. So from this Griswold v. Connecticut penumbra, which creates a right to privacy, through the course of further decisions, like we had the Einstat decision, which applied the same right in relation to unmarried people using contraceptives. It was a matter of personal privacy that the state couldn't invade. We then got the Roe v. Wade decision in the early 1970s, in 1973. And that decision effectively said that in addition to the contraceptions question, outside of that, the specific question of abortion is a matter essentially for the woman to make that decision. But unlike in those other cases, the court went and had to essentially rein in to some degree their position. They said, well, first trimester, breaking it down by trimester, we can't have restrictions on abortion. Second trimester, you may have regulations. You can't have necessarily complete restrictions, but you can have reasonable regulations. Third trimester, the state can completely prohibit abortion under Roe v. Wade. And the rationale for this was there's a sort of pendulum that swings throughout the pregnancy where in the first part of the pregnancy, it's a matter of the woman's rights. And then as we get closer to the end of the second and the third trimester, you start to have the state taking an interest not only in the woman's health, but also in the health of the unborn person. And essentially that is the way the courts established Roe v. Wade to regulate abortion. But the effect of that was a great deal of state laws that prevented or restricted first trimester or early second trimester abortions essentially were struck down as unconstitutional. So, putting it into that wider framework, that's essentially the rationalization for Roe v. Wade as it was in a nutshell.
So what changed now with the recent Supreme Court ruling?
The way that I would look at this is nothing really changed per se. There was pushback even from the time of Roe v. Wade when it was established. There was pushback all the way from then that this decision was incorrectly based. Essentially, the position was that the Constitution doesn't protect a right to an abortion. The dissenters in that case actually did set that out. And the conservative side of the legal profession for quite some time has rejected the application of substantive due process in relation to abortion all the way from the 1970s when the decision came out. So we've had a steady increase of opposition. The real reason the opposition has sort of, I guess, tipped the scales now is because two major factors. Number one is the social and political climate has changed. Back in the 1960s and 70s, we had a very strong sort of feminist movement going on. It was a different era in terms of women's rights, in terms of personal rights, all of that sort of stuff. And that did have an effect on the court. And as well as that, the court also had a different set of legal philosophies guiding it. So after the 1970s, we had much, much stronger influence coming from what was called originalist conservative judges, essentially that made its way into the ordinary legal vocabulary. So originalism, which was the idea that the Constitution should be interpreted either with the intention of the framers in mind or with the original public meaning of the document in mind. So what the document would have meant to the people whose representatives ratified it, rather than the representatives themselves. And that approach to constitutional interpretation has become far more popular and has actually taken the majority on the court now. The majority of the court, I think it's something like 5 of the judges now, are openly declaring themselves to be originalists. And I believe actually recently the Biden appointee, Ketanji Brown Jackson, I think is her name, she actually declared herself, even though she's a progressive, she declared that she's an originalist as well. So the approach to the law has changed, as well as the social climate upon which the court's making its decisions.
On the approach of how law is interpreted by lawmakers and the Supreme Court, what do you predict the future will be like in terms of interpreting law and how it's implemented? Because we do have people coming out now saying, well, this is going to lead to a domino effect of the impact on gay marriage, for example, is a common thing that's coming up. So what are your assumptions on what the implications or what the future might be in terms of how the system interprets law and implements it?
Well, it's actually a really, really interesting point, because the majority in this case actually made very clear that they only apply this case in Dobbs essentially to abortion. It's not being applied to the broader right to privacy that's established by the constitutional penumbra that I mentioned. Essentially, the majority, which was Justice Alito, as well as Gorsuch and Amy Coney Barrett, these three judges, in concurrence, obviously, was Justices Thomas and Kavanaugh. Those three justices on the majority family, they actually said that this judgment just applies to overturning the Roe v. Wade and the Casey decisions. Essentially, they don't establish that this is meant to go any further than that. They don't accept the dissenting judges' criticism that this is going to be applied further. They say that if you assess the historical records and if you assess the historical legal precedents that we have around abortion, that it just applies to abortion, that the right to privacy doesn't protect that. They don't go further to essentially overrule Griswold v. Connecticut or Einstadt or any of those cases. Another case which was really important that people have thrown out is Lawrence v. Texas, which is essentially a substantive due process case from the early 2000s, which struck down laws which discriminated against particular sexual acts that were being engaged in by homosexuals, for example. So struck down what would be loosely referred to as sodomy laws and things like that. The Obergefell case as well, which was the gay marriage decision, was based partially on substantive due process, as well as the Equal Protections Clause of the 14th Amendment. And commentators have said, okay, well, this is going to mean that gets struck down as well. But the majority essentially were extremely clear in saying that it only touches on abortion. And if I can find the quote, I think it's somewhere in my notes here. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. So essentially, that's what they were dealing with. It's outside the scope of the 14th Amendment to them. But with that in mind, we did have the concurring judgment of Justice Thomas, Clarence Thomas, which went further, and he actually did say this should open the door not to attack just Roe v. Wade and Casey. This should go further to actually be the basis of reasoning that substantive due process generally is a legal fiction, that it's something we've invented to judicially get involved in the political system. And that is something which Justice Antonin Scalia, the late Justice Scalia, was very strong on as well, essentially attacking the broader scheme of substantive due process. And he did say the Obergefell and the Lawrence v. Texas cases potentially should be challenged as well. So that has scared the horses in a broader setting. But in my opinion, just looking at the tone of the judgment, the majority judgment, I think it's very much confined to just the abortion case or abortion cases. I don't think it necessarily will lead to a broader application to those other subject matters, but it certainly does open the door to questioning those other judgments.
Well, how are the Democrats trying to respond to the Supreme Court ruling?
Well, it's interesting. The Supreme Court ruling has been taken in a kind of scattershot way by the Democrats. Some Democrats believe that the solution to the problem, because this is a very fresh decision, it can be turned around also very quickly. That's the other thing we forget. If a couple of conservative judges drop off, another challenge can be brought, and essentially you could end up having the Supreme Court turn this around again. So some Democrats are saying that the solution is to add more judges to the court, which has been, bench stacking essentially. There's nothing constitutionally that would prevent them from doing that. I don't believe, from my understanding. It's frowned upon. It was floated during the progressive era in the 1920s and 30s that this was something that could be done. And the Senate Judiciary Committee actually said this is the dumbest idea anyone could possibly float. And it was dead in the water from back then. But in typical Democrat fashion, they're reviving something which even they themselves declared was stupid back in the 1920s and 30s. So there's the bench stacking, and then there's also the potential for essentially creating federal legislation that would be in some way inconsistent, or creating some kind of a legal framework through which they can work. And there have been some ways that they have tried to skirt it. So, for example, there's now discussions of some kind of system where you would have people moved across state lines for the purposes of abortions, because the majority judgment actually does say that we don't think that women can be criminalized for crossing state lines to get abortions in a state where it is legal. So that it is in the majority's judgment that that's a particular exception, that's not something which can be done. So there's questions now whether Democrats will start providing free travel essentially for women to cross borders to go and get abortions in other states. So there's all these sorts of ways around it. The easiest legal way is to just stack the court, or to get more progressives on the court who are willing to reread this into the Constitution. So it all depends.
Well, you mentioned just briefly about there's this idea that states are going to come out and ban abortion, but as you said, Roe v. Wade only protected it in terms of up to 12 weeks. Post then, they said it is then up to the states. And we see that most states have abortion up until 20, 22, 24 weeks. Do you think that any states are going to bring in more restrictions?
Well, it's a good question. I should clarify if I was inarticulate in setting it out. I'm sorry. The trimester approach that was afforded didn't say that you could ban abortion after the first trimester. It said that you could regulate it. The regulations were subject prior to the Casey decision to strict scrutiny, which meant that they had to be on a very strict scrutiny standard, essentially the only option to maintain a legitimate end for the legislature. So let's say it was a women's health issue. The government had to justify, once the burden was shown on women's reproductive rights or on abortion, it had to be shown that that was the only measure they could implement to actually protect women's health. Most of the time, that doesn't really stand up. So the reality is abortion was protected somewhere up to about 24 weeks, something like that. The Casey case actually turned around and made it a viability question. So by changing the trimester rule to a viability rule in Casey, Planned Parenthood in Casey, 1992, we started to get a framework whereby the court was more, in some ways, transparent about it. They said, look, what matters is whether the baby is pre or post viability. 24 weeks was about the margin that they said. Prior to 24 weeks, everything's on the nose. After 24 weeks, it's based upon an undue burden standard. So essentially, whether the regulation unduly burdens the woman's exercise of the abortion right. It's a much lower standard than a strict scrutiny standard, but it's somewhere between that and a rational review standard. So it's somewhere between those two things it's described as. In terms of the way that things have progressed around this issue, and the way things look like they're going to progress from here, state governments, I don't think, will start necessarily banning abortion from conception, but they may start actually narrowing down the scope. So we saw in the US, as soon as the case actually went up to the Supreme Court, a whole lot of states actually put in place trigger laws. And a trigger law is essentially an abortion legislation that is put into place, which sets an unconstitutional standard that is only enforced the moment the judgment comes out in their favor. If it doesn't, it never gets enforced. So some states had trigger laws. There were 13 states that added trigger laws to the book. So the moment Dobbs was published, they could start enforcing those lower standard abortion restrictions. Other states, like I believe Missouri, actually never took their pre-Roe abortion laws off the books. So essentially, those laws just come straight back into play. Whether or not states will start banning it is a different question. I think there's a couple of states which have banned it. There's a whole bunch of others that have cut it down. So we have a lot of discussion in the US right now about heartbeat laws, whether or not somewhere around 6 weeks is the place to be, 16 weeks is the place to be, something like that. But then again, you also have a whole bunch of states in the US that have essentially no limit, like New Mexico. New Mexico will allow an abortion essentially up to the point the baby's born. So you have late stage abortions occurring. And that's created a whole set of other legal issues. So we have in the US what's called born alive laws, which were passed specifically because doctors were coming out and saying, we are doing late-term abortions, the baby's coming out alive, and we are legally obligated to sit there and wait for it to die in a can in the side of the room. So on that basis, they've had to create legal protections for born alive fetuses that have been aborted. So, we have these two polar opposites playing at odds with each other in the US. They're doing it on a state-by-state basis, which makes it somewhat more tolerable, because New Mexico might have that approach. Texas is right next door, and it has an approach of, no, we're not allowing abortion after 6 weeks. So, essentially, you end up having a state-by-state basis, and that's what the Dobbs case actually confirms. It says, look, this is a matter for the people's representatives to determine. So in Dobbs, the effect of the judgment is every state government can regulate abortion basically on a plenary basis to establish no term limit or to establish 6 weeks, 16 weeks, whatever they want, essentially. And by giving the state governments that sort of carte blanche approach, you see essentially competitive federalism being put back into play around abortion.
From the Declaration of Independence, it reads, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Does this have any legal weighting?
The strange thing is, I believe that there is actually a Supreme Court case which deals with this. I haven't had time to actually go and find the exact authority, but the reality is, my understanding is that the Declaration of Independence doesn't actually play any direct bearing upon the interpretation of the US Constitution. It might be in some judges' periphery, but it's not actually a binding legal authority. It should be noted that the Declaration of Independence predates the US Constitution by some margin. Between the Declaration of Independence and the Constitution, we actually had the Articles of Confederation. So we had another set of American constitutional realities. And I don't think there has been a judgment in the US that has actually based itself on the Declaration of Independence as a kind of legal authority. It's generally considered to be an ideal. But if you're talking about life, liberty, and property, we wouldn't be looking at the Declaration of Independence for our authority. We'd be looking at the 14th Amendment. Because essentially that's the purpose of the due process of law, the equal protections clauses, essentially that someone can't be deprived of life, liberty, and property without proper legal standards being met. So that's where we would get our protection. Now, in relation to what we have in this case, we have Justice Thomas saying substantive due process is just a nonsense. But the reality is there is a twofold point here that can be made in a more nuanced sense. The first one is that the one saving grace, I think, of Justice Thomas's judgment in Dobbs is that he relies much more on the privileges and immunities clause in relation to the 14th Amendment. Since the slaughterhouse cases in the late 19th century, that's not been essentially a legal basis for any constitutional findings. They threw it essentially in the bin. But the reality is, privileges and immunities clause is actually a much more suitable basis for a lot of the rights protection that has occurred on the due process of law clause, substantive due process sort of basis. So essentially, the privileges and immunities of a US citizen, it protects fundamental rights, according to scholars like Randy Barnett of Georgetown Law. It protects fundamental rights that have been deeply rooted in the constitutional system of government, in the concept of ordered liberty. And those rights, which are set out, for example, in Caulfield and Coriel, which was, I think, 1828, actually goes through and it sets out basically a whole bunch of rights that you have to your person, to your property, to your house, to contract, to interact. And essentially, those are the privileges and immunities of US citizens. And they can be added to if a right becomes fundamental to the US people over the course of time. And an example that Professor Barnett actually raises is the example of voting rights. So no one would say, after 200 years of development, that the US legislature can go and turn around and create a voting standard which would exclude women or which would exclude non-property owners, as it did in the beginning of the US Republic. The fundamental right to vote has been now entrenched over the course of time, so it's protected as a privilege of US citizenship. So, moving to that sort of standard, that's a really good plus in Justice Thomas's judgment. The negative is that he throws substantive due process completely out the window, which is, and from an originalist perspective, not necessarily the right thing to be doing. An originalist standard would say that those privileges and immunities essentially cannot be overcome even by correct procedurally created laws in a manner that's arbitrary or unreasonable. So essentially, the American Constitution creates limits on power. You cannot have arbitrary or unreasonable laws in that sense. So if someone turns around, and Dan Andrews is a perfect example, just says, you know what, everyone's locked down. Essentially, what we would have in a US constitutional standard under a substantive due process approach is they have to justify that the substance of their decision or their law is not unreasonable. And we actually have decisions all the way from the beginning of the US Supreme Court, going all the way back to McCulloch and Maryland, where the court actually distinguishes between an act of the legislature and a law. And the difference essentially ends up being an act is something that they do, a law is something they can enforce. And it gets into this very, very nuanced discussion essentially about what actual substantive due process would look like without expanding it throughout, this giant scope. So there's a broader conversation that has to happen, I think, among the scholars and trickle into the judicial ranks. But at the end of the day, I think there's good and bad aspects, even on the conservative side of this judgment. On the substantive due process point, undoubtedly, some of the modern substantive due process is just outrageous. The Roe v Wade stuff is a good example where they have concocted this essentially, where it was never a fundamental right in the US. It was never considered a fundamental constitutional right until the court declared it to be so.
How, in terms of determining what is a right, how far do you believe from a legal perspective that the Supreme Court should go in terms of determining what a US citizen is entitled to? Does it then become to a point where, well, can you put dentistry as a human right, for example? I mean, so how far, because if you go to a certain point, can you essentially just put anything in there?
Well, this is one of the issues that Justice Thomas essentially is hearkening on, and what he goes towards is by saying, well, effectively, you can assert anything in this progressive worldview is a right protected by the due process of law clause. Excuse me, and we get this incredible difficulty where you raised it. It's like, if healthcare was to be declared a right by some people, does that make it a right constitutionally protected? And on that issue, I would say the declaring of a right has to be a fundamental right if it's going to be constitutionally protected. That's why I mentioned voting as a modern right that's become implemented over the course of time. It's deeply rooted, it's fundamental. The rights which would be guaranteed, I think, through the 14th Amendment on the states are essentially those first 8 amendments of the US Constitution. So we'd be talking free speech, freedom of religion, we'd be talking gun rights, we'd be talking due process of law, essentially warrant processes, no double jeopardy, all that sort of stuff. Also, no cruel and unusual punishment, stuff like that. But then when we come to the 9th Amendment, we get issues because we've got unenumerated rights. The 9th Amendment protects unenumerated rights of US citizens. So essentially, in that clause, we have it said, just because a right isn't in the Constitution doesn't mean its non-referral or its lack of textual basis can be used to disparage its existence. So I think that means the court actually has to play a role in checking to see whether a right is unenumerated but fundamental. Some jurists say that the 9th Amendment means the courts have no place in establishing unenumerated rights. That's for the legislature. I personally, as an originalist, would say that the courts do have a role in checking whether an unenumerated right is fundamental enough to warrant constitutional protection against arbitrary usurpation or abuse. But with that said, that requires a very significant evaluation as to whether or not it meets the criteria of a fundamental right. And for you to establish that, I think there's a whole lot of boxes that need to be ticked. And it's not just longevity or the length of time with which something has become accustomed. I think it has to be something which is relied upon, something which is agreed to, something which has been widely accepted for a very long time. And on that basis, I don't think Roe ever really met the standard, because it wasn't something that was across the board that we've all accepted in the they all accepted in the United States as being a given. In states like Texas, it was always something imposed. Whereas stuff like voting rights, since the late 19th century, it's been accepted that there is a standard of voting rights that is increasing, essentially, from enfranchising African American people to broadening it to women, to include a whole bunch of other people. Essentially, it's something which cannot be reversed at this point.
We've got an audience question. Isn't the overturning of a 50-year-old precedent damaging to the legal process?
That's a very good question. I think actually Justice Scalia, before he passed away, actually did mention, and he in a number of decisions after being appointed to the court, dealt with abortion matters and actually did dissent on the point that he said abortion rights are not protected in the US Constitution. And if I can just find a couple of those cases, I have the references here. You should look at the cases of Stenberg and Carhart, Gonzalez and Carhart, and also the case of Planned Parenthood and Casey, and Webster and Reproductive Health Services. So essentially in those cases, the last one being a 1989 case and moving forward, Justice Scalia was essentially taking issue with the existence of the abortion right on the basis that this right doesn't exist. But in interviews that he gave outside the court, he had actually made the point that after 50 years, it's a piece of law which has essentially been relied upon. It's protected by a kind of stare decisis, which is essentially the principle of precedent. We can't just overturn it, or something along those lines was what he would discuss. And that has some merit. Justice Scalia, he very much sat on that side of the fence. There were a number of cases that came to the court. He refused to actually overturn precedent on the basis that it was long-standing. And in some interviews he gave, he would say, as a conservative jurist, he would say, well, if you want to take issue with McCulloch and Maryland from the early 19th century, or Marbury and Madison, which was, the seminal case from US constitutional law, can you just go and reinvent the wheel for 200 years of jurisprudence? He thought it would be nonsense to go and do that. But on the other side of things, we have another question, which is, if something is wrong, but it's been long established, does that mean we should continue on the incorrect pathway? And the best example of that is the decision of Plessy v. Ferguson, which is the separate but equal decision from the late 19th century that was handed down. The Plessy v. Ferguson decision essentially said that despite the 14th Amendment, despite the 13th Amendment, despite the 15th Amendment, African American people can be segregated from schools. They can be given their own schools. The schools have to meet the same standards as white schools. They can be separate, but they must be equal. Okay. Now, this standard separate was never equal. We all know that from the history we've read. But that standard was extremely perverse, and it was based upon this kind of rationale. Now, if you turned around and you said, okay, well, it's wrong, but it's been established for 50 years or 60 years, we would never have had Brown v. Board of Education. So we would have never overturned the separate but equal doctrine. We would have never ended segregation in that legal context. And originalist scholars have said that's why, if you have a decision which is not properly based on the law, it's not deeply rooted in the system of government, in the concept of ordered liberty, as much as it might be painful to go and overturn 50 years of jurisprudence, it is better to do that rather than continue down the incorrect pathway. And I think that's actually something, not much of this can be applied to Australia, but that is something which I think actually the Australian jurists should note, because there have been a number of decisions in this country that have been extremely incorrect, that have led to perverse consequences, that are not within the concept of an originalist approach to constitutional law. And at the end of the day, we continue to apply them simply because they're being long established. So I think on that basis, I would actually agree with the majority. In this case, it was necessary to go and actually revisit Roe v. Wade.
You briefly mentioned about the implications on Australia. Do you think that there will be anything from this on Australia and jurisdiction and regulation? Because that tends to be an argument among a lot of people right now, where they're coming out and saying, well, this will come to Australia, when really we regulate it by the states here in Australia. It already is how we regulate abortion. So it makes no sense. But what's your perspective? Do you believe there's going to be any type of domino effect onto other Western countries?
Isabella, I think that's it's actually a really good question, because there has been a lot of hysteria in Australia about this. I think every politician, particularly on the Labor side of politics, and I don't know why this is the case, has come out and made some kind of comments about this Dobbs v Jackson's Women's Health Organization case. I have no idea why. I mean, you had the French president making commentary on it. And the funny thing is, in most places in Europe, abortion is more restricted than in most US states. It just doesn't make sense how they can come out and make this sort of comment. But also the terrible, terrible arrogance of particularly Australian politicians and pundits to think that they are suddenly US constitutional law experts, that just because a judgment's been sitting on the books for a while, it means it can never be overturned and it's essentially invincible from criticism, is just extremely arrogant for us sitting on this side of the aisle to be talking about. We're not talking about it in an academic way. They're making a political statement about the constitutional rights of American citizens. It is wrong. It just shouldn't be. It shouldn't be treated like that. And in previous times, I don't think any Australian politician would ever have said that. They would have never called out the US Supreme Court like that, because we're talking about essentially the most elite court in the Western world. This is the court. They're interpreting the oldest constitution in our Western hemisphere, essentially. And we have Australian politicians calling them out. But also, we have people manufacturing hysteria that doesn't actually make sense, because our system of government already deals with abortion in the exact same way the Dobbs case sets out. Dobbs says that it's a state issue. In Australia, it is strictly a state issue. We deal with it on a state-by-state basis. And the best example of that, in New South Wales, abortion is legally accessible up to 22 weeks. In Tasmania, it's only accessible up to 16 weeks. I guess the women of Tasmania must be somehow absent a great deal of advocacy or something, because that's been the case for some time. We've been dealing with abortion like this essentially the entire time we've been here. There's never been a constitutional right in Australia to abortion. There's barely a constitutional right in Australia to protest about abortion. There's been a number of cases that have found that people can be restricted by state legislation from protesting outside abortion clinics. And there's been onerous rules that have been set on your ability to protest abortion in Australia that have been completely constitutional. Or protest anything, not just abortion, I should say. But the reality of the situation is it doesn't have any direct legal effect in Australia. There isn't any direct legal effect. Whether it's the overturning, whether it's the precedents, nothing. We don't have a first, we don't have a third, we don't have a fourth, we don't have a fifth, we don't have a ninth, we don't have a 14th Amendment, we have nothing. There is no Bill of Rights. You don't have any constitutional rights effectively in Australia, save for Section 80, a right to a trial by jury, which has been watered down to the point it doesn't apply to 90% of criminal offences, because they're all dealt with by the state governments. I mean, it just doesn't affect, legally speaking, Australia in any significant way. Culturally, of course, there might be an argument to be made that that decision in the US is a pro-life decision, which it isn't really. The majority even said in the case, we reject the calls to ban abortion just as much as we reject calls to protect through a constitutional right abortion, because they've had both. They had amicus briefs coming out the wazoo saying that the right to life should be established as a constitutional right. So abortion should be banned across all 50 states. The US Supreme Court rejected that. The judgment is essentially neutral. It says that abortion is a sticky issue, but it's not a federal constitutional issue. It's a matter for state governments. We have the same thing in Australia. In South Australia, recently, abortion was decriminalised. We now have abortion in South Australia. I think it's up to 22 weeks and 6 days. And in every state, we have abortion after that, subject to, I think, usually it's 2 doctors' approval for medical reasons. So, whether we set the limit, it's low, for example, like Tasmania, 16 weeks, or we go all the way up to the other end of the spectrum, which would be the Northern Territory, 24 weeks. After that, for a health reason, 2 doctors can approve your abortion and you can still get one. The only place where abortion is have at it is essentially in the ACT, where there's no limit. There's no gestational limit. You can go in there, I'm 38 weeks pregnant and I want an abortion. State by state, territory by territory, the people of each place decide. And at the end of the day, that's the way it should be. It should be a matter for each state to decide. One rule fits all does not work.
We've got another audience question. Can you explain the concept of viability in a bit more detail? It seems extremely arbitrary. If privacy is such a fundamental right, why did Roe allow states to impose any restrictions at all on abortion?
Well, it's a good question. In terms of viability, the way the court has looked at it is essentially viability determined by medical science. So viability determined by medical science right now would be after 24 weeks or somewhere around that marker, the fetus has essentially a potential to survive outside the womb through medical advances and whatnot. The odds, I think, of a fetus surviving outside the womb at 24 weeks is somewhere around the marker of 60%, but I'm not a medical scientist. I don't know exactly. It could be a whole bunch of research on this I'm not aware of, but what I've read is it's about 60%. So it's still not great. And because of that, after that marker, the fetus becomes more and more capable of surviving outside the womb. The government, essentially the US Supreme Court said under Casey, has an interest, and also under Roe, an interest in protecting the health of the woman and also protecting the health of the baby. And the reason it's protecting the health of the woman is, my understanding is, after 24 weeks, having an abortion can actually have impacts upon women's health as well, because it gets more and more invasive as time goes on, effectively. Prior to 24 weeks, or within the first trimester, I think is probably the easiest way to discuss it. There are less invasive ways of having an abortion. And that's why they say, essentially, because the baby isn't viable outside the womb prior to 24 weeks and it's less invasive, it doesn't affect women's health in the same way, the government should step off and it's a woman's decision under Casey and Roe. But as I was mentioning, in relation to, for example, banning it from the get-go, a lot of people have made the argument that, well, because the fetus has a potential to hit 24 weeks and become a viable life, there shouldn't be any abortion at all. It should be completely prohibited, because you would presume that fetus has the potential to be a full-grown person in 20 years. On the other side of the aisle, they say, well, if there's a right to privacy and it's none of your business up to 24 weeks, why does it matter what I do after 24 weeks? And that's the, essentially abortion completely unrestricted argument. Essentially what the court did in Roe v Wade and Casey, in a practical sense, is try to apply a kind of balance, balancing the rights of women to an abortion and to their own body and to their own medical decisions, and the right of, I should say, the just power of the states under their police powers, which are plenary powers in the US, subject to the Constitution, to make regulations for public health and well-being. And essentially balancing those two things was what the court was trying to do in Roe and Casey. Obviously, it doesn't even matter. The balancing act doesn't even matter if you turn around and say what the majority said, which is, this isn't any of our concern. This isn't a federal constitutional matter. So the Supreme Court essentially in Dobbs has said, we don't need to talk about viability at all, because that's a matter for the state policymakers to decide. Viability, non-viability, 6 weeks, 16 weeks, whatever it is, that's a matter for policymakers. It's not a constitutional issue. So essentially they avoid it in that sense. And if it's constitutionally correct to leave it to the states, that's where it belongs. That's how it should be.
What is your take on how the media is presenting this issue at the moment, and how there is this huge backlash to it? I mean, in my opinion, it comes off like it's a storm in a teacup. It's really not grasping what it is, which it's not banning abortion. It is purely giving it back to the states. So what's your take on how the media has approached this and how they've spun this in a way that's trying to cause an outrage?
Well, I think the media has tried to spin this as an attack on women. But the reality of the situation is it doesn't come off like that, because the majority in their case very explicitly say, we know that this is a sensitive issue. We accept that this is a sensitive issue in Dobbs, but it's not influencing whether or not we're making a particular legal finding. Our legal finding is based upon the historical evidence and the historical reasoning that we apply to what the 14th Amendment means, what the Constitution means, and essentially what the state governments can do under their police powers. And by applying the history, they say there's no basis for the Roe v. Wade and Casey decisions. essentially, the media have turned around and said, because the Supreme Court is refusing to uphold this right to an abortion, which is, as I said, it's been in decline since Roe v. Wade anyway. It's been dropping in standards from Casey essentially onwards. More and more regulations were capable of being founded around it. Essentially, by decentralizing it and giving it back to the states, the media have turned around and said the courts have attacked women's rights, when ultimately women's rights in the states where they were able to have abortions have been protected. And in other states where they were already severely under pressure in relation to abortion rights, the only thing that's going to happen is the few places that are providing abortions will either have to cut down the amount of service they can provide because the limit has now dropped, or alternatively may just have to close up shop. And if women are not happy with that, if they want an abortion, it's not like Australia where there's 6 states and they're all kind of the same. And you look at the list, they're all basically the same. It's very cooperative federalism in Australia. In the US, you can go from Texas, cross state lines into New Mexico, and you can get an abortion basically the day before the baby's born. It's completely competitive. The decision just allows local populations, and I mean local in the sense that, people that live within this jurisdiction, Texas, Missouri, whatever it is, to decide for themselves what the values of that society are around abortion, giving it to them in the same way that liberals, or I should say progressives in the US context, not liberals, would say that marijuana should be deregulated, should be decriminalized. They're happy when California decriminalizes marijuana because that's competitive federalism. We got one state decriminalizing marijuana, the other state will throw you in prison for 5 years for having a joint. They're glad that they've got competitive federalism when it comes to something like that, because they're people, when they're living in California, they're happy to decriminalize. Everyone here agrees that marijuana should be decriminalized. Cool, let's all smoke up. Well, people in Texas say, no, we don't want the marijuana, and we also don't want the abortion. But the people in California must be able to go and get an abortion in Texas. There has to be an abortion right in Texas. Well, we're talking about a right to your body. I have a right to smoke marijuana. Why not? At the end of the day, I'm putting something in my body. What's the difference? I should be able to consume whatever I want. I would argue that that's part of the privileges and immunities ultimately as well within the US Constitution. You should be able to. There shouldn't be any restriction on these things. But ultimately, the US Supreme Court's found those regulations are completely valid because they're part of the public health and well-being sort of framework of laws that can be made. State by state, each state has the ability to regulate any of these topics to the extent that they wish. And that's the approach the Dobbs case sets out in relation to abortion, competitive federalism. And ultimately, that's as far as it goes. It doesn't go any further to disparage abortion or make a policy judgment. It just says it's not our domain anymore. And that's where it is. It's just been blown up in terms of importance. I think the more important decision that, progressives in the US should be blowing up about, if they're being consistent, but they didn't because, this is a more loaded issue, abortion. I think it's the case name is Bruin. It was essentially striking down on Second Amendment grounds, New York handgun rules, so that people have been affirmed the right to open carry or to carry handguns essentially within New York City. And that's something which you would expect in light of what's going on in the US, they'd be much more angry about. I think that decision was rightly decided as well. But ultimately, that decision, there is probably a much more active argument that could be made than the abortion decision, because that one actually says that states can't make laws concerning guns. This decision says that they can make whatever laws they want about abortions. So you can have a state, if you can convince 30 states out of 50 to have open abortion rules, all 30 states can have rules in relation to abortion being up to 38 weeks. But no state is allowed to regulate handguns. So, if you were going to make an argument that I think would stand up, that would be the place to make it in relation to current Supreme Court decisions. This case, I think they've made, a monster out of essentially a mouse.
Right. Well, central to the issue of abortion is whether the being in the womb is a human being or not, and if it is, what protection should it have? Why are primary sources regarding what happens in relation to abortion, why are they not allowed in the public debate, be it online or on TV? Are there legal repercussions for this?
I'm not probably qualified to say if there's any legal repercussions in particular contexts. I've heard that there might be some restrictions in relation to whistleblowing in some places in relation to Planned Parenthood. that there can be sometimes repercussions for people doing that, but I'm not aware of anything generally speaking that criminalizes that. What I think in relation to the policy of abortion is different from what I think into the legalities of abortion in a US context. I would, as a judge does in the US, I would separate that as a lawyer quite distinctly. I think legally, I'd probably come out more on the side of the majority. I think the majority is probably correct to a degree. Same as Justice Thomas, I would agree to an extent with him. Policy-wise, I have my own views on abortion, which I've made public during the election as well that recently passed. I think the reason it doesn't get discussed what happens during abortions is because A, there's a whole bunch of different procedures that count as an abortion from different periods of time. B, some of the descriptions are quite odious and quite graphic. And C, at the end of the day, the people who normally will conduct the abortions, they generally speaking don't want to talk about what happens during an abortion or what goes into an abortion. You can see some physicians, they're uncomfortable with some of the procedures, but at the end of the day, they are also, as physicians, counterbalancing what they see as the medical issues that might be giving rise to the abortion or the social issues. Justified or unjustified, I don't stand in judgment. It's not for me to say. But at the end of the day, you have some physicians that are in the political domain that are OB-GYNs like Ron Paul and Rand Paul, who have said that they performed or they were present during abortion procedures, and they talked about how odious the procedures are, especially once the fetus has reached a certain point. And they have been in some ways censured by the modern left because the realities of what happens during an abortion, particularly a late stage abortion, as I said, with things like born alive laws that have had to be passed, they can be really graphic. I mean, we're talking about what could be essentially a baby crying in the side of the room, and we all have to ignore it because it's been aborted, not born. And that is something which is harrowing. We don't generally want to talk about that. But if you look at the signs of some of the pro-abortion activists in the US, they're very clear. They don't care about any of those issues. There are quite a few of them that would be happy to abort essentially what is a full-term baby. So you have people that are, on this wavelength and within the mainstream media, very, very conscious of this issue. They want to preserve this as an issue. They want to preserve this as a right. They don't want this to be, essentially changed. They want this to be maintained as it is. They don't want to discuss the ethical implications in a policy setting of abortion. They don't want to discuss the rights of the unborn, their human rights, their right to life, any of that. Because once you start discussing the rights of the person that is being aborted, you detract automatically, in their view, from the rights of the woman who has to give birth to them. And their focus is on the woman, not on the person that's being aborted. So that is the difficulty which we have here. We have two different sets of people, pro and anti, and they are talking from different moral perspectives, completely different moral wavelengths. The pro are talking about women and the unrestricted right of women to an abortion, with very little care about what is inside the woman's womb. You had some women in the US wearing their t-shirts up high and writing on them, still not a human, even though it's very clearly late second, early third trimester baby. So you got people like that. And then on the other side of things, there are some people that would say, well, I dismiss the question about women's rights altogether. The only question is whether there's a right to life for the person within the womb. I think that a good healthy democratic dialogue would include discussion by both sets of people, as well as people in the middle, physicians, ethicists, lawyers like myself, who are able to discuss whether or not the government being involved in this is A, successful, and B, whether or not particular policy strategies are successful, but also what is the ethical implications of what we're doing. Is allowing a woman to abort essentially what is a full-term baby, a healthy full-term baby, ethical? I think the question has never really been addressed in any public forum that I've been in. And it's been largely dismissed by the modern left completely. In the same regard, I think a lot of people on the right, and I'm very happy to say I'm pro-life in a moral sense, not in a legal sense. I'm more on the judicial side of things. I like to look at it from a legal perspective, but generally morally I'm pro-life. But I don't discount the fact that if you make abortion completely illegal, and this is what the dissenters said in the Dobbs case, if you make abortion illegal, there will be a section of women who will still go and get this procedure done, and they will do this procedure on the black market, which will be more dangerous to women's health. It will be more dangerous to the health of the baby, and it has the potential to create, as I said, black markets where people who are not trained are benefiting from women's desperation. And that is something which is extremely worrying as well. Even if you're pro-life like me, you would also accept that that is something which we have to account for before we make any policy decision. We have to account for the fact that people are going to make decisions that we don't necessarily agree with. We have to make sure we minimize the amount of harm that they are going to be putting themselves in by making that decision. And that doesn't just apply in my worldview as a liberal Democrat or as a libertarian to abortion. That applies to drugs. That applies to a whole bunch of other activities. Harm minimization is extremely important because people will go and do with their body essentially what they will. The idea is we just don't want a whole bunch of people dying from essentially illegal abortions. We want to find a policy which is balanced and which makes sense balancing all these interests. But the only way we can do that, Andrew, is essentially we have to have a very clear dialogue about the ethics, about the practicalities, all of those things. And at the moment, you simply can't do that because the moment you come out and say, like me, I'm morally pro-life, but I do have these concerns about women's health. I want to talk about it. They say, well, pro-life, I don't want to talk to you. There's a lot of people out there who just don't want to talk to you if you're pro-life or if you have a position that is ethically concerned about abortions generally. There's a whole bunch of people on the modern left that don't want to talk to you. Same way, if you're moderately pro-choice, I have many libertarian friends that are. There's a whole bunch of people on the conservative side of politics that just will not engage with you because you are advocating for the killing of babies in some sense. And that, as much as they're dedicated to their convictions, that doesn't make for a very robust public discourse. As a society, we are dealing with people that have extremely different perspectives in a policy framework. We have to find out through successful open dialogue what the correct approach is. And we have to continually assess that over the course of time. Now, without saying what I think is the right policy point here, because I'm talking in a legal context, just on the question of the dialogue, I think that's something which is going to have to be improved to make sure this issue isn't politicized to the detriment of either unborn persons or women generally.
I just have one quick question because I know we're running out of time. For your legal perspective, say that a late-term abortion was to occur within a state, and then there were the ramifications that female then later on experienced mental trauma and was essentially, or what experienced physical or mental ramifications from that, and then wanted to hold someone legally accountable for allowing her in her vulnerable state to participate in a late-term abortion. Is the state then liable? Are they able to hold the state against that and say you should have stepped in and protected the people of the state and put the health of the people of the state first and regulated it?
If we're talking in an Australian context, the answer is generally no. The answer would be generally no because you can't really sue the government for laws that they didn't make or for rules they didn't enforce. You might be able to sue a medical practitioner for negligence if they gave you a procedure which was medically negligent. But if you're talking about psychological harm, which is something which would be outside the control of a medical practitioner, let's say an OB-GYN performing an abortion, I think that in the civil courts, you'd have a very hard time establishing that doctor ought to have foreseen the risk and negligently essentially didn't address that risk in giving you an abortion, because psychological injuries can come about through a whole host of things. We've generally accepted that, for example, workplace bullying can cause psychological injury because we have a whole bunch of studies that say that that's something which is essentially has a direct relationship to that. In relation to abortion, there's a huge number of women which would have an abortion and think nothing of it, and there's a whole lot of women I've read about these cases of women who have ended up having extreme guilt and feelings of depression after an abortion, because as much as they thought that was the right decision at the time, they also feel extremely negative about the fact that they don't have what could have been a baby in their arms. There's a whole lot of studies about the mental health impacts of abortion. But with that said, I don't think you'd be able to sue a doctor if the abortion was legally conducted. If the abortion was illegally conducted, and in most places, I think basically every place, the woman isn't punished for an illegal abortion. The practitioner of the illegal abortion is. So when I say if we made, let's say, abortion completely illegal, the framework would generally be you don't punish women, you would punish the service provider. So you'd punish the, street corner OB-GYN who's performing, back alley abortions. Whether or not that person could then be sued in civil law for giving that woman an abortion, I think obviously would come into play because they were doing something which was illegal and which was not authorized. They were acting obviously negligently. There might be a case to be made, but at the same time, there's also potentially some joint liability here. The woman undertaking an extremely risky abortion procedure in someone's back room probably is accepting a higher degree of risk than she would if she was in the hospital. So even if you were to sue, not that I think you'd probably get much, but even if you were to sue, ultimately there'd also be a question of how responsible the woman was for the decision making to do this as well. So there's a whole bunch of factors here. I just don't think that necessarily would be the case. I think the best way to look at the mental health implications of abortion is through a policy framework. I don't think necessarily lawsuits would be the way to rectify that issue. I think mental health counseling and mental health facilitation for women that have had abortions probably is something that would need to be looked at if that is a significant issue that psychologists are finding women have after getting abortions, particularly late stage abortions. But you can only have that, like I said, if you've got a robust policy dialogue. Going back to what's going on in the US, the one thing you can say that did come from this, with all the polarization, is in every state where there are abortion laws that are on the fence, where you've got a good progressive conservative sort of swing going on, you will have very robust discussions about mental health implications, about women's rights, about rights of a person to be born, all of those things. And they will find a marker for abortion laws that are somewhere between the two factions, between no abortions and all abortions. You'll find a middle ground between these two, slowly oscillating somewhere in the second trimester or beginning of the second trimester, I would say. And that seems to be the product of greater discussion. So the one good thing that will come from this is you will have those discussions, but in countries like Australia, it's sometimes hard to have those discussions because the media is so ossified and it really doesn't want to air the kind of conversations that do happen in America, because they have the benefit of 50 separate states where you can have those conversations on smaller scales. In Australia, it's 6 states. You got 5 media outlets. You got the ABC, which is pumping communist garbage 24/7. Essentially, you can lock down the conversation for one side in Australia very, very easily.
Yeah. Well, we are now out of time. This is one of the most thorough discussions we've had on the show. Cameron Shamsabad, founder of the Australian Constitutional Law Journal. Thank you so much for coming back on the Sunday sessions.
My pleasure. Thank you very much, Andrew. Thank you, Isabella. And thank you to everyone that tuned in. Very glad to join in. And if there's ever any other legal topics I can canvass, whether it's American or Australian, I'm very happy to join Macquarie University Liberals once again.
Well, we'd be happy to have you back. Thank you so much for coming on. This has been a Macquarie University Liberal Club production. My name is Andrew Kremen, and I've been joined by Isabella Anderson. We will see you next week.